Okay. All right.
All right. This term of Manhattan County Court is now in session with the Honorable Robert L. Bauer presiding. Please be seated.
Nicholas Angelo.
People against Nicholas Analone, indictment 25035. We adjourn this matter to today's date for argument and decision with respect to the defendant's omnibus motions. Or is it received defense written motions? Also, the people's written response. Did either side wish to be heard any further?
Briefly, Judge, thank you. Cognizant of the appearances yesterday, Your Honor, we are largely going to be resting on the paperwork. I would just like to highlight the jurisdictional and constitutional arguments briefly that we raised in our motion. I want to be clear that it's not, it really isn't just like some sort of semantic or philosophical argument. It's a real question of constitutional concern, and as the Court of Appeals makes out, a question of separation of powers. As the Onondaga County Special Prosecutor points out at page 4 of their answering affirmation, they make reference that once the Attorney General's office found a conflict, it properly disqualified itself. That's the language that they use. Which of course is not what happened, or could happen, right? They went to a judicial body, a judicial branch under 701 and asked to be disqualified and have another special prosecutor assigned. The fact that Onondaga County, which is certainly another constitutionally protected prosecuting authority, was chosen is certainly not what's mandated by 701. Local attorneys can act as special prosecutors when assigned and otherwise. So the theory and the statutes that are being utilized here, while in this case may not have directly resulted in that type of authority being taken from the executive branch, nothing would stop it from being done in any other case. I would note that, a lot of times too, under 701, a defendant or defense attorney will raise and request a special prosecutor be assigned for an alleged conflict or other type of issue. And the Attorney General's office, as we're aware, represents the New York State Police in many matters. And so that's a major area of 70B legislation when the AG's office gets involved in deaths at the hands of law enforcement from the New York State Police. And now you'd expect, is there possibilities that they're going to be conflicted out of utilizing that type of authority in any matters that involve New York State police officers that they've represented in civil matters. And it's different than when the special prosecutor raises that Oneida County was left with no jurisdiction here when 70B superseded. That's not what 70B does. Yes, they do gain that superseder authority, but the statute specifically allows for Oneida to still act when granted various authority from the Attorney General. The reason that I think is important, Judge, is it shows that 70B hasn't disqualified Oneida County. If it had, then the AG should not be allowed to have it act in various ways in the investigation and prosecution because they were disqualified. Instead, it functions for one executive constitutional authority to act supersedingly and over another one, but not a disqualification. So Oneida never actually got disqualified, and whether or not it makes sense or whether or not it would be easier to allow for the transfer of jurisdiction or power to prosecute and investigate these cases, if there's more efficient ways to do it, I agree, but that's not what we're dealing with when we're dealing with the constitutional authority to prosecute a case. So I think that that is a major question here and a hurdle that was skipped when the Attorney General's office, rather than return to Oneida. Now, also I would mention in their affirmation, the special prosecutor makes reference to the fact that it makes sense and there's a reason why 70B takes authority away from local prosecutors for transparency and otherwise. And I understand that makes sense, but again, 70B doesn't take it away. They could return that and Oneida could fully and constitutionally be involved. If Oneida believed it had a conflict, which we have no idea about, but if they did, Oneida has that opportunity to make a 701 motion like county prosecutors do as needed and have a special prosecutor assigned because of their conflict. But that was skipped. So for that reason, Judge, that I think is worthy of comment on additionally from their response, and as to the other parts of our motion, the rest on our brief. Thank you.
Thank you, Counsel. Mr. Hudson?
Thank you, Your Honor. I'm going to start with the last argument that Mr. Ivanovich raised there. The statute does explicitly say that the Attorney General takes full authority over a case once they decide to supersede. Full authority. That they have a vestigial permission that they can give whatever they want back to Oneida County doesn't change the fact that from the time that they supersede, that becomes their case. So going forward, it's theirs to do with as they will. So it doesn't matter whether Oneida County was disqualified or not, because it wasn't their case anymore. By an act of the executive, the Attorney General's office took control. So there's no real separation of powers issue here, because it's one executive branch, the Attorney General's office, taking control over another. And of course, the governor and the Attorney General's office are the top law enforcement body for the state. So there's not really much dispute that they could do that. They did. And once they chose to do that, I don't follow how the Attorney General's office, then following the exact same procedure that a district attorney would follow in having a special prosecutor assigned, creates some issue that now the judiciary is involved and is going to intervene. After all, if that's true, then 701 by itself creates that issue. That's the issue that Mr. Ivanovich is concerned with. The Attorney General properly followed the guidelines laid out by statute once they superseded and became the prosecuting authority. As far as whether they disqualified themselves before seeking judicial authority, I don't think that really matters as well, because again, they adhered to the procedure laid out in County Law Section 701. They said, we believe we have a conflict, we're asking a judge to step in and assign a special prosecutor. So again, and I think the language of Executive Law 62 is pretty clear on this, that once the Attorney General's office takes a case over, they are functionally the district attorney for that county in every way that matters. They have all of the powers and all of the duties of a district attorney for that county. That includes the duty of, we see a conflict, we need to step aside. And doing that and following the exact same procedure that any county district attorney would have followed was the proper way of handling it. And there was just one more issue that was raised on the papers here that I do want to get into, and that is the authority of Administrative Judge Karalunas to actively be the person that assigned a special prosecutor. I'm sure the court is aware of this. There is a standing a standing yearly order that governs exactly administrative procedures like this. And by that order, Judge Karalunas, as administrative judge for the entire 5th Judicial District, which does include Oneida County, appointed herself as one of the judges capable of assigning special prosecutors. So in every way, this was done properly, and it was done as it should have been, specifically to avoid the separation of powers concerns that the defense raises. As for everything else, Your Honor, we would rely on the briefs.
So then, as to the defendant's motion for Sandoval and Venamigli hearings, that motion is granted. And any such information must be turned over to the defense no later than 15 days before the first scheduled trial date. As to any motions relative to discovery, both sides were reminded of their respective obligations under the CPL and may involve the court if there's a genuine discovery dispute. As to the defendant's motion to preclude non-notice statements, that motion is denied at this time, but with leave to renew should the people seek to introduce such evidence in the future. The defendant's motion to suppress statements made to law enforcement is denied at this time. However, the court will grant the defendant's motion for a Huntley hearing concerning the voluntariness of such statements. And as to the defendant's request for an audibility hearing, the court can address audibility in connection with recordings that I assume will be admitted at the Huntley hearing, and I'll address that in camera as may be necessary. As to the defendant's motion to review the grand jury minutes, that motion is granted. The court will review the grand jury minutes in camera for sufficiency, and that is to include the legal instructions given. As for the suppression hearing, counsel, I have available August 12th through the end of that week. So Tuesday through Friday, based on your availability.
And I was just checking Teresa Francos as well, Judge.
Thank you.
If Friday's available, Judge, the 15th?
15th is available. So 10:30 a.m., August 15th. Mr. Analone, that's when you're next due back in this court. It'll be August 15th, 10:30 in the morning. We'll have your suppression hearing at that time, and then we can move on to talk about scheduling your trial. I'll see you all back here.
Thank you.
Thank you. Your Honor, before the headway, I do have a thumb drive that I'm handing to the defense counsel now. If I may approach the court, there's been some reference in the motion papers to search warrants in this case, and we do have all search warrants in this case that we're providing to the court. These have been previously provided to defense counsel in discovery packages.
Okay. You can pass that up. You acknowledge receipt, counsel.
Acknowledge receipt, Your Honor. Thank you.
Very good. Thank you.
Michael Fisher.
Good morning, Your Honor. Scott Eisman for Michael Fisher, just standing behind you here in the court. Good morning, counsel.
This is the matter of the people against Michael Fisher under amendment 25035. This matter is calendar today for argument and decision. The court now having received the defense written motions and also the people's written response. Did either side wish to hear any further, Mr. Eisman?
Your Honor, I also submitted a reply on Monday. I'm not sure
I received that as well, yes.
if should work out. Briefly, Your Honor, I'm mindful of how the court has responded in the other cases, and so I won't belabor certain points, but I do want to address the court's attention to a couple of issues that were highlighted in our motion. So our relief that we are seeking is at two different levels. The first is dismissal of count 5, which is the only count that the defendant faces under the indictment. And the second relief has to do with the alternative if the court doesn't do that, how to proceed at that stage. And so with respect to the motion to dismiss, we provided multiple independent reasons why the indictment is facially insufficient, as well as the evidence supporting the indictment is legally insufficient that was presented to the grand jury. And I won't belabor the details that we point out in our papers, but I do want to highlight that in the people's answering affirmation, they have further changed or further particularized or articulated their theory of accessory liability here, which has to do with the element of which mental state are they accusing the defendant to have shared with the principal actor. Is that he is only charged with being an accomplice. He's not charged with being a principal and an accomplice. He's only charged with being an accomplice to manslaughter. There is no principal for manslaughter charged in the indictment. There's only accomplices charged to manslaughter. He is one of them in count 5. We asked for particularity, and a bill of particulars, whose mental state does he share, which is a requirement under Penal Law 20. We also asked, what was their theory? Did he aid, did he importune, did he support a principal actor in committing the criminal conduct that he's accused of being an accomplice to? In the People's Bill of Particulars response, they said, every single co-defendant, he shared the mental state of every co-defendant in the indictment, every single one. That includes Officer Gentile, who had nothing to do with any type of homicide crime. And then they also said, and or, that's their language, quote, and or, every single DOCS employee who testified at the grand jury, which includes all sorts of folks who aren't even criminally implicated. Now, in their answering affirmation, they say that Defendant Fisher is accused of sharing the culpable mental state of those who are involved in depraved indifference murder. I've cited in my reply papers People v. Feingold, Court of Appeals case, which holds that the mental state of depraved indifference murder is not recklessness, as the people are claiming. It's depraved indifference to human life. And so their theory of accomplice liability is wrong. It's not pled accurately in the indictment facially. They have not established whose mental state he shared, as is required under Penal Law 20, or how he aided. There's no factual allegation in the indictment about how he aided or supported or importuned any principal actor in the face of the indictment. Now they have these multiple theories of bill of particulars and an answering affirmation, and an affirmation is a sworn statement that they're bound by, about whose mental state he actually shared. And if the court is not going to dismiss this indictment based upon the independent reasons that I've cited, then it has to pay particular attention to how the grand jury was instructed on accomplice liability. And I'm requesting that those instructions be disclosed to the defense so that we can inform the court and provide the court with our feedback on what those instructions were and whether they were legally appropriate or not. Because the shifting theory of accomplice liability and whose mental state was shared is confounding, and I think demonstrates that how the grand jury was instructed is probably not accurate and needs to be paid particular attention to. And not only the instruction, but what theory did the grand jury actually return the indictment on? People can't change that theory. They can't later say that we have a different theory than what the grand jury returned. They're bound by the theory that the grand jury returned it on, and that requires careful inspection by the court. And I think under these circumstances, because of these changing responses about whose mental culpability the defendant is accused of sharing, the defense is entitled to see what those legal instructions were so that we can properly respond and inform the court on what our perspective would be on those issues. The last issue I'll raise has to do with legal sufficiency. There were 3 independent reasons why the evidence before the grand jury was not legally sufficient. I've already talked about the mental culpability issue, so I won't belabor that. The one that I will mention is causation. They have to prove causation. It's a necessary element. Their answer to everything is, he has a duty. That's their answer to everything. Every single element almost is their answer is, he has a duty. Duty does not provide evidence of causation. They effectively want strict liability. they don't get strict liability. They have an affirmative obligation to establish each element of the offense by a prima facie case at least at the grand jury. And they can't do that for causation. And if you look at their answering affirmation, they basically don't even try to answer it. They don't pay attention to People v. Raymond, which is what we've represented to be the controlling authority on this issue. People v. Raymond is a Fourth Department case where the Fourth Department affirmed the dismissal of a manslaughter count based upon legal insufficiency of causation at the grand jury. And in that case, you had an impaired driver, an intoxicated driver, who was accused of leaving the scene where his passenger had been injured and not timely seeking medical care. And the Fourth Department said, well, there wasn't any evidence that medical care, or that failure to provide medical care in a timely way or obtaining it in a timely way caused the death. They have to prove causation. And then, as we detailed in the brief, the Fourth Department said there isn't even evidence that medical care could have been obtained within that period of time, that medical care would have resulted in a different outcome at the end of the day, or even what that medical care would have been under the circumstances. And that isn't directly analogous to here, where they're saying that Corrections Officer Fisher had a duty to intervene, but they don't provide any evidence to say that an intervention at any particular time, even if it was immediate, the second he saw that there was some sort of unjustified use of force, he immediately intervenes, that would have resulted in a different outcome. They have no evidence to say from a medical expert that if intervention had happened 6 minutes earlier, that a different outcome for Mr. Brooks would have happened. There's no medical evidence to suggest that. They have to prove causation. It's a necessary element, and they fail to do so. If these arguments are not convincing to the court and we get on to the other relief, we're heading more towards a trial outcome here, Your Honor, which I don't think we do, but just to cover my bases. After the court, if we're not going to be granted the grand jury minutes on the instructions, then we must have a more meaningful answer to the bill of particulars. These two competing theories of their response to the bill of particulars and then their answering affirmation have us in a position of, I have no idea what their theory is. And we have to have a meaningful idea of what theory I am defending on if we're going to trial. Who is it that we aided? Who is the principal actor? Whose culpable mental state did we share? We need that in bill of particulars. And Your Honor, we're also requesting a severance. I won't get into the issues beyond it, but I think that a severance is going to be necessary in this case for the reasons that we stated, not only because of the number of defendants, but also the brutal issues that are going to be inevitable in the case itself. So I'm happy to answer any questions that the court may have, but otherwise rest in our papers now.
Thank you, Your Honor. First of all, as far as the indictment itself goes, there's not really any requirement that a principal be charged, nor is there any requirement that the defendant share the same full mental state of the principal actor. And there's case law to support that. I believe we cited in one of our motion responses at the least, but in case we didn't, it's People v. Nelson, 178, A, D as in Delta, 3rd, 1395. Pages 1396 to 97. And that is a Fourth Department case from 2019. I don't want to belabor the facts too much, but the gist of that case is that there was a gang assault. 3 people jumped the victim. The main defendant, Mr. Nelson, had handed a knife to one of the other defendants before the attack took place. Mr. Nelson didn't notice or didn't see that defendant using that knife to stab the victim. So the Fourth Department looked at that, saw that Mr. Nelson was attacking the victim, was participating in the attack, but there was no evidence to prove that he had the principal actor who was stabbing the victim with a knife. He didn't share that intent to cause serious physical injury. The Court of Appeals didn't dismiss outright the charge of gang assault in the first degree. It reduced it to gang assault in the second degree, because it found that the evidence did support that Mr. Nelson intended to cause physical injury, a lesser standard, to the victim. Now, the man stabbing Mr. Nelson, the principal, had intent to cause serious physical injury, but because physical injury is included in serious physical injury, that was enough for the Fourth Department to say, we're not dismissing that count. You were found guilty now of gang assault in the second degree. The same logic covers here. Mr. Eisman can't argue that recklessly causing somebody's death in a way that evinces depraved indifference doesn't include recklessly causing somebody's death. Manslaughter in the second degree does include that requirement, and we do allege that Mr. Fisher recklessly caused Mr. Brooks's death by having the same duty to intervene that we've talked about at length yesterday and not acting on it. And I think there's a difference at the grand jury level, certainly, in saying we've provided no evidence whatsoever that an intervention would have saved Mr. Brooks's life, when there's video of this entire attack, and we see Mr. Brooks conscious, moving, responsive, while Mr. Fisher is in the room watching the beating going on and doing nothing to stop it over and over and over again until eventually Mr. Brooks does stop. And the evidence is certainly, for the grand jury level, clear enough that if someone, anyone in that room had gotten them to stop the beating, Mr. Brooks might have survived. So, Your Honor, I submit that we have established both that he did, and the language of shared mental state comes out over and over again in accomplice liability cases, but that's not the standard. The standard is that this defendant possessed the mental state for the crime to be committed. All we have to prove is that he was reckless, and that he aided somebody who was reckless and more in bringing that about. And I also cited in our papers, People v. Wong, that is in this specific brief. That case as well involved two people with a duty to act, and ultimately they couldn't prove that either actor was the one responsible, so that case was dismissed. But the Court of Appeals in Wong at length talked about how the people's theory throughout was that the passive defendant who did nothing, whichever one it was, still aided in causing that child's death by doing nothing, by not getting any medical intervention. And the Court of Appeals specifically gave a stamp of approval to that theory. We're not really breaking any boundaries here. This is all well-trod ground. As far as the grand jury instructions, Your Honor, there's really no benefit to Mr. Eisman having them. We're under no obligation to provide it. CPL 245 is very clear. We have to provide testimony. We don't have to provide instructions. We've provided the instructions to the court. Mr. Eisman has raised his concerns in the court. We welcome to look through the instructions that we provided with those objections in mind. Giving him the actual instructions won't change anything. We submit that those instructions were more than sufficient. Now, lastly, as far as the bill of particulars goes, Your Honor, we have been consistent throughout this case that his duty to intervene and his failure to intervene was what supplied causation. We stand by the fact that there's plenty of evidence of recklessness elsewhere in the record. We're not worried about that. But that's always been our theory. We've never had a theory that he's somehow planned any of this ahead of time or that he actively participated in any way. We've been very clear, very upfront, and very consistent. Our theory depends on his duty to act and his failure to act on that duty. As far as severance goes, Your Honor, we will stand by our motion response, but we are certainly comfortable navigating Bruton in this case, considering the wealth of different sources and perspectives we have to provide any piece of information we need. We're very confident that we can redact anything that needs to be redacted to keep any of the co-defendants from implicating any of the others in a way that deprives them of a right to confront their accuser.
Anything else, Mr. Eisman?
The only other thing, Your Honor, is on the causation issue. Is that evidence will show in the grand jury, and this is the people's own proof of the grand jury, that when Corrections Officer Fisher left the room after observing him for 6 minutes, that the initial medical evaluation revealed that Mr. Brooks' vital signs were stable. They were stable when he left. They want to say that he knew that he was at a substantial risk of death. The evidence directly contradicts that, and that's the last point I want to make.
If I may just respond to that.
Yes.
I apologize. We would note, though, that Mr. Fisher did receive yearly training on use of force, strangulation, positional asphyxia, all of those things were brought to his attention on a yearly basis that he was required to certify in, and he observed all of those things being done to Mr. Brooks. We certainly submit that he was aware that there was a potential risk that Mr. Brooks would die from what was happening to him, and there's no evidence whatsoever that establishes that Mr. Brooks ever woke up from this attack.
As to the defendant's motion for Sandoval and Benamigli hearings, that motion is granted. Any such information is to be turned over to the defense no later than 15 days before the first scheduled trial date. As to the defendant's motions relative to discovery, both sides are reminded of their respective obligations under the CDL and may involve the court if there is a genuine discovery dispute. As to the defendant's motion to suppress statements made to law enforcement, that motion is denied at this time. However, the court will grant the defendant's motion for a Huntley hearing concerning the voluntariness of such statements. And the court will also review the exhibits I assume will be admitted at the Huntley hearing to address audibility as may be necessary. The court will also grant the defendant's motion to review the grand jury minutes in this case. Those will be reviewed in camera for sufficiency, that is to include the legal instructions given. The court, upon that review, will give consideration to the defense request to release those instructions. As for the defendant's motion to compel the prosecution to file more responsibility particulars, I'm going to reserve on that for now. I want to re-review the exact verbiage in the People's Bill of Particulars. I will also reserve for now as to the defendant's motion for severance. With respect to the suppression hearing, Mr. Eisman, I have available August 12th, 13th, and 14th.
August 12th, Your Honor.
August 12th it is. That will be at 10:30 a.m. So, Mr. Fisher, that's when I'll next need you back in this courtroom. August 12th, 10:30 in the morning for your suppression hearing. Mr. Hudson, did you have the same materials that you needed to supply?
I did, Your Honor.
Acknowledge receipt, Your Honor. I'm sorry, did you say 10:30 or 10?
10:30.
10:30.
10:30, August 12th. I'll see everyone back here then.
Thank you, Your Honor.
Mayaw.
Good morning, Your Honor. Allie Von Stackelberg for Michael Mayaw.
Good morning, counsel. Your last name again?
Von Stackelberg.
Von Stackelberg?
Von, V-O-N, yep.
Got it, thank you.
It's a bit of a mess, Your Honor.
No, that's fine. This is the matter of the people against Michael Mayaw, indictment 25035. This matter is adjourned to today's date for argument and decision with respect to the defendant's omnibus motions, and the court is now in receipt of the defense written motions, also in receipt of the people's response. Did either side wish to be heard any further? Counsel?
Yes, Your Honor. Just briefly, understanding, of course, that the court heard argument yesterday on many of the same arguments that we made in our papers, as well as Mr. Eisman's arguments that he just laid out, specifically regarding mental culpability for accomplice liability, same causation arguments that we've raised in our brief as well, Your Honor. But I do just want to add one point with respect to the omission part. I understand Your Honor heard argument on this point yesterday. However, having not been here for those arguments, I just want to cover a couple of points for Your Honor. Specifically with respect to omission, the position of the prosecutors since the beginning of this case, and we just heard that again in Mr. Fisher's case, is that each of these defendants, including Mr. Mayaw, owed a duty to intervene, and that duty to intervene can serve as the basis of either an omission for the purposes of accomplice liability or perhaps some other sort of criminal liability. They point to this duty, but it's actually just an assumption. There is no legally recognized duty to intervene in criminal law. The positions that the people cite in their opposition, they have not provided a single case nor a single statute that recognizes such a duty to intervene in criminal law. Even the case of People v. Wong, which the people just discussed and which was mentioned in our brief as well, addresses a very clearly recognized duty to intervene in criminal law in a parent-child relationship. It is a completely different, separate, very well recognized duty in criminal law, and it is not a duty to intervene by law enforcement. Instead, they're assuming that this duty should be extended. And I would specifically note for Your Honor that there is, in fact, and there has been for many years, a bill before the New York State Legislature which would make it a crime for law enforcement to fail to intervene. But that bill has never passed. It is not yet the law that a failure to intervene by law enforcement can be the basis of criminal liability. So the assumption that a duty to intervene somehow automatically translates to criminal culpability is simply that. It's just an assumption on the part of the people. It is not actually the law. With respect to the other arguments, Your Honor, we would rely on our papers. Specifically, Mr. Eidman discussed this as well, but our arguments with respect to facial insufficiency of the indictment, as well as sufficiency of the proof. And if the court has any questions, I'm happy to answer them, Your Honor. But besides that, we would rely on our papers.
Mr. Hudson, did you want to be heard?
Very briefly, Your Honor. Certainly, we don't need to go back to the well as far as the parent-child relationship. I would just remind the court of our arguments yesterday that that duty itself comes from a definition in family court law. So certainly, we think that the authority we've provided provides just as clear of a basis for a duty of care for correction officers as that definition does for the parent-child relationship. We'd also note there was some argument yesterday, and I don't know if Ms. von Stackenberg was trying to get to this exactly, but we're not asking the court to find any broad universal duty of law enforcement, period, here to intervene. The duty that we are putting forward comes from specific statutory authority for peace officers that gives them powers contingent on them acting in their duties and responsibilities of their job. Their duties and responsibility of their job thus incorporates the DOCS regulations that, especially given the unique dependence that an incarcerated individual has on correction officers to protect him, feed him, clothe him, shelter him or her. That is where our duty comes from. So finding a duty of care in this case would not suddenly open the floodgates to every single law enforcement officer, because we're not relying on those statutes for that duty. Other than that, Your Honor, I believe our brief adequately covered the bases, and we'll rely on that.
Thank you. As to the defendant's motion for Sandoval and Benedict hearings, that motion is granted. Any such material is to be turned over to the defense no later than 15 days before the first scheduled trial date. As to the defendant's motions relative to discovery, both sides are reminded of their respective obligations under the CPL and may involve the court if there is a genuine discovery dispute. As to the defendant's motion to suppress statements made to law enforcement, if that motion is denied at this time, however, the court will grant the defendant's motion for a Huntley hearing concerning the voluntariness of such statements. The court will also grant the defendant's motion to review the grand jury minutes in this case. Those will be reviewed in camera for sufficiency. That is to include the legal instructions given. The defendant's motion for a Friday hearing is denied. As to the suppression hearing date, counsel, I'm down to August 13th or 14th.
We do August 13th, Your Honor.
Okay. 10:30 a.m. Mr. Mashaw, that's when you're next to be back in this court. August 13th, 10:30 in the morning for your suppression hearing. Mr. Hudson, did you have those materials you wanted to supply?
I did, Your Honor. Thank you.
We acknowledge receipt. Thank you, Your Honor.
All right. Thank you, everyone. I'll see you back on the 13th.
David Walford.
This is the matter of the people against David Walters under indictment 25035. This matter is adjourned to today's date for argument and decision with respect to the defendant's omnibus motions. The courts received the written motions of the defense along with the people's written response, and I did also now receive your reply affirmation, Mr. Passalacqua. Did you want to be heard any further?
Just briefly, Your Honor. I think that just a couple of points that are worth highlighting with regard to our motions and the people's response. As laid out in our motion papers, and as I indicated to the court previous to that filing, it's our position that the people materially and erroneously manipulated the video that was presented to the grand jury in this matter. As we've shown in our motions, somebody at some point, unbeknownst to us, that has not been disclosed, added name tag labels to these videos, which our position is that is inappropriate and inadmissible hearsay. They were offered for the truth of the matter that that person displayed was that name tag. That was the name of that person that was being displayed.
So we're clear, Mr. Peslak, what you're referring to as manipulation of the videos is putting name labels on them?
Yes, Your Honor.
Go ahead and continue.
I think it most appropriate to have it, we point out that one of the name tags was a completely false name. That is clearly misleading to the jury. Why do we know that? Because as we've laid out in our motion papers, the grand jury came back multiple times asking for clarification as to who was who. At one point, I believe they asked specifically for a lineup. Now, the people suggest it's not hearsay, it was to help the grand jury. Their intention aside, it had the opposite effect, clearly. In their verified answer to the court, they assert that it's okay. Every name that appeared on the screen, written, was verified by a witness on the stand. And they gave citations. Well, I looked at those citations, and I looked throughout the entire almost 500 pages of the grand jury transcript, yet I didn't find a single witness that uttered the name David Walrath, because no such person exists. Yet that was the false and misleading name that was presented on screen on an individual that was not my client. And I think it's telling that the people ignore that in their response. They don't mention the completely false, fabricated name that was presented to the grand jury. And probably in hopes that the court would ignore it as well. But I would suggest to the court that their representation that a witness identified each label as accurate is a false representation to the court. No one ever uttered that name. I find it more compelling that, as I mentioned to the court previous to filing, I had a conversation with Mr. Hudson about those issues, to which he explained to me that, oh, that's no big deal. The court will see this as an excusable hiccup. But never mentioned it in their responsive papers whatsoever. I think it also telling that now, again, as we articulated in our motions, we were never in receipt of the original video without name tags. We were only given the video with the name tags placed throughout the videos. And as we articulate in our papers, the original on the body cams have been destroyed. So the only way for them to bring the video back to its original state would be to further manipulate and remove those name tags now. And I think it's just telling that in 15 years of practice in 25 counties in this state, I've never seen a prosecutor ask the court more vehemently to look outside of the criminal laws for guidance and inference on how to handle defendants' requests. The fact is, with our requests, primarily for the grand jury hearsay issues and our request for dismissal, they find no support in the statutory or criminal case law in New York. So they're asking the court to sidestep and reach into family law and others for guidance. We would suggest to the court, we've provided relevant case law, criminal case law in the state of New York, directly on point. They have not. With that, we would rest with regard to the remaining arguments on our papers.
Mr. Hudson, did you want to hear?
First and foremost, Your Honor, The allegation that we have not provided the original body-worn camera to Mr. Pasalacqua is absolutely unequivocally and demonstrably false. They have had that body-worn camera in its full and unedited condition from the very first provision of discovery in this case, and that was in March. If Mr. Pasalacqua has been unable to locate that video, we would be happy to help him find it, but he does have it, and he has had it. So the notion that we're going to come into open court and make an accusation that it was never provided without first going through those steps when 6 other defense attorneys over the last 25 hours have none of them raised that issue, we find that deeply problematic. In any case, not only do they have the original body-worn camera footage, but Grand Jury Exhibit 4 contains a clip titled Trombley Video, which is the exact same portion of the original body-worn camera footage that the nameplates were then added to for Grand Jury Exhibit 8. So for multiple levels, we object to the fact that that was even brought up. Now, as far as the original body-worn camera being destroyed, that also is categorically not true. There was an expert affidavit provided by Brian Childs, who is an expert that was hired specifically by Axon, specifically to go through body-worn camera footage. And in that report, he noted that recall footage, once, in order to look at it, it has to be uploaded off the body-worn camera, and then it's deleted from that body-worn camera. We could not have looked at anything in this case without removing it from the camera, but it was preserved in the exact same condition it was in and downloaded. On top of that, there was some reference, I believe, in Mr. Pasalacqua's reply brief that the investigator Musso was capable of looking at the body-worn camera footage without it being deleted. That's also not true. The reason that that footage was able to be contained in the full Axon package from Mr. Childs is because investigator Musso provided access to Doc's Axon share mainframe, their cloud, directly to Mr. Childs, who was able to provide that, run the audit trails, and compile all of this information. On top of that, every time we provide body-worn camera footage, in any case, it is always removed from the body-worn camera itself. Every time we have an activation, that comes about because the body-worn camera is put on a charging port, and then the activations are then transmitted out immediately, deleted from the body-worn camera footage, and sent on. So essentially, Mr. Pasalacqua is accusing us of misconduct for providing discovery in the only way that that discovery can be provided. Your Honor, we submit that that motion should carry very, very little weight, if that. And while we're on the subject, we would note that the one mistyped name in Grand Jury Exhibit 8 was attached to a person that was very visibly another defendant in this case, Christopher Walrath. His name was correctly identified within a minute beforehand on the same video, in the same area. I believe he might leave the frame in the intervening time, but I'm not even positive on that fact. In any case, it is very clear that the same person being shown with the correct name immediately beforehand, the one small typo should not completely undo the entire grand jury presentation, because of course the grand jury was going to be confused on who's who here. There were 10 named defendants, multiple additional cooperators, and then on top of that, multiple other people who were also on the video. All of them wearing Doc's uniforms, all of them looking not inconsistent from each other. Given all of that, we submit that it was necessary to provide the grand jury some kind of guidance to keep track. But I would also clarify that I think Mr. Pasalacqua was misreading our argument a little bit as to why the nameplates on Exhibit 8 and also Grand Jury Exhibit 9 aren't hearsay. It's not that it was just to help the grand jury and that's why it's not hearsay. It's not hearsay because it's just matching what the witness identified. So it's not for the truth, it is this is who this person identified this visible person on the video asked. So again, we acknowledge there's one mistake on the screen for maybe 1 minute or for maybe 3 seconds rather, over the course of, again, more than a dozen people who had their nameplates presented, who were shown doing the various actions that were captured on that video. But we submit that any argument that that somehow should undermine the entire grand jury process is just unfounded. Other than that, Your Honor, we would rely on our papers.
If I may respond briefly, Your Honor. I just want to clarify that it should not be seen by the court as a simple mistake. It wasn't that it said Big Bird. No, it's clearly not Big Bird. It said David Walrath, displaying an individual, like they all had, CO uniforms. Displayed a man with a hat and a beard. That day, my client was wearing a hat and a beard. And you're asking the grand jury to differentiate David Wall something when they're asked within a day or two of seeing that to vote an indictment on a David Walters. That's absolutely prejudicial, misleading, and just false. So while the people would like to poo-poo it and brush it under the rug, I think it carries much more significant weight than they're suggesting, given the nature of the mistake, as the people will call it. But with that, I will rest my papers.
As to the defendant's motions relative to discovery, both sides are reminded of their respective obligations under the CBL and may involve the court if there is a genuine discovery dispute. To the extent there are discovery disputes, the parties are hereby ordered by the court under Article 245 of the CBL to first diligently confer with one another and work out any discovery issues. The defendant's motion to preclude non-notice statements is denied, but with leave to renew should the people seek to introduce any such evidence in the future. The defendant's motion to suppress statements made to law enforcement is denied at this time. However, the court will grant the defendant's motion for a Hunt hearing concerning the voluntariness of such statements. The court will also grant the defendant's motion to review the grand jury minutes in this case. Those will be reviewed in camera for sufficiency and are to include the legal instructions given. As to the defendant's motion for sanctions relative to a claimed failure to preserve the original body-worn camera videos, the court is reserving decision as to that. As for the suppression hearing, counsel, going last, you're down to my last available date. That's August 14th.
Fine, Your Honor, absolutely.
August 14th, 10:30 a.m. Mr. Walters, that's when you're next due back in this court. Hudson, did you have materials you need to provide?
I did, Your Honor. Thank you.
We would acknowledge receipt, Your Honor. Thank you.
I'll see you going back here then, August 14th, 10:30 a.m.
Thank you, Your Honor.
All right, and with that, we'll take a short break if the media wanted to.